Rob. I organize Idea the IPO. We've been doing events in Silicon Valley for many, many years. We have a busy calendar of events. I want to highlight a few events that are coming up. This Thursday at WilmerHale in Palo Alto, that's January 30th, a venture capital panel, hottest trends for 2020. Later on in February, in collaboration with Startup Grind, we are promoting Startup Grind Global Conference 2020. It's their 10-year anniversary, and our members get 15% off. So check out the details for those events and all of our events on our website, ideaipo.com. We launched officially on February 1st, 2010. At that time, we had no members and no events on our calendar. At this stage, we have over 70,000 members among all our meetup groups in the Bay Area. We've organized, promoted, and produced over 2,150 events. We're the most active, most prolific startup event organization in Silicon Valley, bar none. Thank you. So actually, since February 1st, 2020 is a few days from today, we are actually celebrating our 10th anniversary all this week. So there's going to be a celebration today, tomorrow, Thursday, Friday, and Saturday. So all the events on the calendar will have a form of a celebration. We have two events that are not on the calendar. They're private events, but if you talk to me, you'll get an invitation, hopefully. Our mission is to promote entrepreneurship, support entrepreneurs, build community, and provide value in the Silicon Valley startup ecosystem. To that end, we provide content that's practical, actionable, and relevant, stuff you can actually use to succeed as entrepreneurs. And we believe in building community because Silicon Valley attracts people from all over the world who come here to do great things. Who here is not originally from Silicon Valley or the greater San Francisco Bay Area? Who here was born and raised in Silicon Valley or the greater San Francisco Bay Area? Two natives. All right, let's hear it for the natives. So in addition to our content-oriented events throughout the week, we also have some fun social events on Friday nights. And the next one happens to be this Friday, January 31st, at the Hyatt Regency Santa Clara. And it's hosted by Colby Lepore and Joe Ashwood. So let's hear it for Colby and Joe. So that's a free TGIF mixer at the Hyatt Regency Santa Clara. It's a free event. You're all invited. With regard to value, it is important that we provide value at each and every one of our events. So we make sure that our events are affordable because we know many entrepreneurs are struggling financially. And if you cannot afford the cover charge for whatever reason, come talk to me and we can work something out. And at each and every one of our events, we make sure that we provide a delicious buffet meal. Is this a delicious buffet meal? Yes. Well, I want to thank Royce Law Firm for sponsoring that delicious buffet meal. So let's hear it for Royce Law Firm. Royce Law Firm is also sponsoring the cake, and we have some Haagen-Dazs ice cream. So stick around. That's all going to happen at 8:30 p.m. at the end of the formal program. So thanks for stepping up, Royce Law Firm. Most importantly, though, at each and every one of our events, we want to make sure that we provide value for your time, which is your most valuable resource. I always have to ask, is anyone here getting any younger, besides our speaker? So when you invest your valuable time to come to our events, we want to make sure that you maximize your ROI. We have many, many partners that help us do what we do. Law firms, venture capital firms, angel investor groups, incubators, accelerators, co-working spaces, colleges, universities, lots of players in the Silicon Valley startup ecosystem. Tonight, we're grateful to TechCode for hosting us at this beautiful venue. Is this a beautiful venue? So let's hear it for TechCode. So if you want to find out what happens at TechCode, come talk to me. I can connect you with Sean Flynn, who's the general manager here. There's a lot of great stuff going on here. We have other partners here tonight. I would like to also have them be acknowledged and have them come up and say a few words. So let's hear it for Pramal and City National Bank. Applause.
Hello, everybody. I'm from City National Bank right here in Palo Alto. I mean, it's Sunnyvale up here, but we do a lot of events at Palo Alto, so it's closer to my branch. just here, if you have any questions about deposits, lending, or anything, let me come and see me. The rates are pretty low right now, so if you have any questions on commercial or residential, just come and see me. Thank you.
Let's hear it for Anita and Happiness Factors. Applause.
Thank you, Rob. I'm Anita, the founder and chief strategist at Happiness Factors. At Happiness Factors, we create happy mindsets, and we do that without using drugs, alcohol, or marijuana. We strive to be the global leader in everything emotional wellness and happiness, and make it so easily available that you can have your happiness at your fingertips. If you want to know more about it, come find me later. And I'm also looking for a game developer and some people who are willing to help me beta test my new product. Thank you so much.
And I always like to reiterate that at our events, there is no drugs or alcohol or marijuana. We do have chocolate mousse cake and ice cream, and I think that's acceptable. Just check. So here's the schedule for the rest of the evening. Our featured speaker will present. He's got an awesome slide deck. Audience members, hold your questions until 8 p.m. At that point, we'll open up to audience questions. If you want a copy of the slides, you can email Roger directly. We'll take questions from 8 to 8:30 p.m. Roger will take as many questions as possible. He likes to emphasize he's not giving out legal advice. He's giving out information, but he is not charging. So take advantage of that opportunity. So without further ado, I want to introduce our featured speaker tonight. He is one of the top corporate and startup attorneys in Silicon Valley. He's the founder of Royce Law Firm. And frankly, he is an iconic figure in Silicon Valley. He's everywhere. He's at meetups, conferences, charity events, at the Rosewood. He's everywhere. And he's passionate about helping entrepreneurs succeed. So let's give it up for Roger Royce.
All right, thanks, Rob. Thank you all for being here. I'm Roger, the founder of the Royce Law Firm. We're about 30 lawyers based in Menlo Park, with offices in a few other places. We're a full-service law firm, but mostly what we do, almost all of what we do, is technology startups. And I've been in the Valley for a long time, and I work with companies. How many entrepreneurs here, by the way? Okay. Any investors here? All right. Oh, there he is. I found him. So we work almost exclusively with tech startups. I've been doing it for a long time, and over the years, certainly have gotten to understand what it takes to get a company to venture financing. And I gather you're here because you want to find out what you're going to have to do for your company. Now that's sort of a mixed legal and business issue. And because I'm a lawyer, we're going to talk a lot about the legal side of this, but also some of the business issues and some of just the startup stuff that you're not going to find written down anyplace. Let's get this out of the way. Not legal advice, but just good information, as Rob says. So question number one, I want to pause on this for a minute. This is usually a pretty easy answer, but still a little more thought how to go into this. So now you've got an idea, maybe you've got a couple co-founders, and you think you might have somebody, a rich uncle who might put a little money behind it, and you've got some IP and you're ready to launch this thing. The very first question you're going to have to ask is, what kind of company should I be? Or should I even be a company at all? Almost all of the startups in this valley, are what we call Delaware C corporations. Delaware is the state where it's organized. The C designation means that is a tax thing. It means that it's a separate tax-paying entity. Almost always. The reason why is because that's all that the venture capitalists will invest in. And even though you're not ready for venture capital today, you're hoping that you're going to get some down the road at some point. So it's usually a little easier just to start out as a C corporation if that's the way you're going. Now, I just want to pause on this for a minute and tell you that usually there's a little more of a discussion around this, and everyone should take a step back. In 2019, I did, I think, the 6th or 7th deal exit for one of my serial entrepreneur founders. He's done several companies like this, and Now he's done, now he's retired, now he's going to go be an investor. And I did the first deal with him, I think 25 years ago. And he created a company, he built it, and he sold it. Every single one of them was an S corporation. He did it right here in Silicon Valley. He built it, and he took money. You know, it was a little tricky, but we were able to take money from investors. But he did that over and over again as an S corp, not as a C corp. And it got me thinking, you know, gee, I wonder what would have happened. What would the difference be if he had been a C corp? And the difference in tax savings was millions and millions of dollars over his lifetime, over that 25 years of building and selling it. So it's not an automatic, you know, it's your default, but you ought to think about it. For him, he wasn't going to issue preferred stock to venture capitalists. He was going to build it till it hit somewhere between $30 and $100 million, and he was going to sell it. So he didn't need venture capital money. So it made a lot more tax sense to make the S election. It's the kind of a calculus you ought to go through when you form your company. Now his is the kind of company that he could build it up, it became profitable, and it was saleable even without venture money. So that's not most of my clients in Silicon Valley, but that's some of them. And you ought to think about choice of entity. Now, on the other hand, here's how I look at it. If you're the kind of company that's going to be profitable, if you're a lifestyle business, and you're going to be able to basically generate enough income to pay the owners, that maybe you want to do something very tax efficient, like a limited liability company or an S corporation. They're tax efficient, they're called pass-throughs, because there's one level of tax on their income, and it's at a very low rate these days, since 2017. If, on the other hand, you're the kind of company that is either going to raise a lot of money and become a very big company, or you're going to be nothing at all, then you're a candidate, then you're a C corporation. That's a classic venture capital type play. So that's kind of how I usually think about it. The reason I'm talking more about it right now than usual is because the scales have tipped way in favor of C corps. And there's this thing you need to know about early on, so don't mess this up. It's called qualified small business stock. And since 2010 now, investors in qualified small business stock can exclude all of the gain. They don't pay tax on any of their gain from the sale of their stock. No federal tax, up to $10 million or 10 times their cost. It's a huge benefit. Everybody knows about it. Every investor thinks about it. They're going to want you to tell them they're getting qualified small business stock. And the first thing that your company has to be in order to offer that is it has to be a C corporation. All right? And it's not just your investors. It's you too. You, the founders. You know, the stock that you get in your company qualifies for this benefit as well. So there's really good reasons for being a C corporation for the typical startup. So I just want to pause on that because I still see a lot of companies formed as something else, and there may be good reasons for doing it, but probably not if you're going to be the kind of company that's going to be a venture capital play. Choice of jurisdiction. What do you think the #1 state is for incorporation? Delaware, yeah, clearly. I mean, I'm a California, in fact, I'm licensed in 6 states. None of them are Delaware, but 99% of the companies I form are under Delaware law. It is just the standard, right? Everybody, it is internationally recognized. And again, because of where we are, why is that? The venture capital industry drives that. VCs want to invest in Delaware corporations. I can give you all the technical reasons why if you want to know, but suffice it to say that that's what you're going to have to be to get venture capital funding. So again, it's a lot easier to just start out as a Delaware corporation than to be a California corp and then try to change later. Or worse, be an LLC and try to change later. You can do that, but it's a lot easier to start out your life as a Delaware C corporation. Other states. I'm hearing Wyoming pop up a lot lately. And you all know why. Have you heard about Wyoming? Anybody here in the crypto business? Blockchain in the back? Okay. So Wyoming has a bunch of laws, state laws that are very crypto friendly, right? There's a regulatory sandbox for crypto businesses. You know what I mean by crypto, cryptocurrencies and tokens, digital assets. And there's like one lawyer in Wyoming who went off and got a degree from Harvard and came back to her state and has just been on a rampage to turn Wyoming into the model, for a crypto-friendly jurisdiction. And a lot of companies are locating there just to do crypto, to do mining, to do development, to do sort of crypto businesses. with that one exception, you still ought to be in Delaware as a general rule, but you'll see Wyoming pop up. Nevada, we used to see Nevada a lot, not so much anymore since they changed their laws a few years ago to make every company there have a business license. So you want to be in Delaware. Enough said. Let's talk about your team. And almost everybody in the room is a startup entrepreneur. Does everybody have a co-founder? Let me put it this way. How many of you do not have co-founders? Oh, okay, so that's 4 of you, 4 out of this crowd. So typically it takes a village. Typically, most companies I see, they have a technical person and a business person. And the investors that I talk to, they all seem to agree that they really, really, really want to see a technical co-founder. Are you technical, Anita?
No, but I have a secret.
Okay. Well, you got to have somebody who's got a lot of skin in the game, who's going to, put the effort in that it takes on the technical side. If you're a tech company, obviously, who's, and that's somebody who does more than just work for a salary or a wage or even an hourly. So most investors, they're going to say, I want to see a technical co-founder. Not always, maybe you find a workaround. Maybe you're such an awesome business person that you can contract that out. Maybe you've got enough personal money, you can hire that. As a general rule, it usually takes more than one person. So that's where things get complicated. If there's just one founder in the company, all of this stuff gets way easier, right? Because you don't need vesting, you don't need employment agreements. One founder controls everything. Now you've got co-founders. So now we have to put in place all the mechanisms that it takes to make sure that the people are going to work together towards the right goal. Now, 2 things on founders, and I get this question all the time. It's how much equity should the founders have? How do we divide the equity? There's 3 of us. How should we split it up? The most common way is, probably the worst way, is just equally. 3 of us will split it 3 ways. I see that more often than not. Another way people do it is they do some sort of formula, sort of. I'm full-time, you're part-time, so I get 2/3, you get 1/3. That's a little better, although it sort of rewards the person that can negotiate the hardest. There's another method called dynamic split. It's basically a formula that changes daily depending on how much effort each of the parties puts into the venture. If you're interested in learning about dynamic split, you can go to the website www.slicingpie.com and download some of their tools. And there are others, but that's one of them that I've seen a lot. And it'll give you an example of some formula that you can put in. So at any given day, every day people come in and they enter their time, the money they put in, the supplies they provided, the IP they contributed, they weight it, they value it, and we just add up the value of their inputs, and their relative value is their relative percentages. It's pretty simple that way. So why am I talking so much about this? There's a study from Harvard Business School from a few years ago that showed that companies that used a formula or a dynamic split or something like that tended to be valued at least 20% higher than companies that just did the split equally. Okay, this is Harvard, so I believe them. Statistically, they've shown that you actually get a better valuation if you use a little more sophisticated way of valuing the company. So keep that in mind. Most companies don't think about that as much as they should, but just keep that in mind that you might want to think about something other than just equal split. Why do you suppose that is, by the way? Why would they get a higher valuation? I think we don't know, but intuitively it seems that I think, first of all, the investors are not going to price the company as high if they think the wrong team's in place or if the incentives are all wrong, right? Secondly, people might not work as hard if they think they're supporting a slacker, someone who's got more stock than they should have. And thirdly, the person who doesn't have as much stock as they should might not work as hard either. Secondly, advisors. Most companies have advisors now. Now, by advisors, that's different than a founder, it's different than a consultant, it's different than a director. An advisor is that person that you need for that one particular area of expertise, right? You're getting into a new vertical, and you need somebody who has a big Rolodex and can introduce you to all the right people. Or you need someone that can close some big contracts starting out. Or you need someone that can help you meet the investors and find money. I'm an advisor to several companies for stuff like that, or I used to be. The thing about advisors is they're not fiduciaries, they're not directors, they're not officers. You know, they're basically engaged for that one little specific thing. Maybe it's technical advisors. So the question comes up, well, how do we attract and retain and reward advisors? So you're a startup, you got a lot of equity, you don't have a lot of cash, so you're going to give them equity, right? How much equity should you give an advisor? First of all, we all know what an advisor is, right? You're going to hire that technical superstar to help you get your product to, to your beta or to, a minimum viable product. How much equity do we give them? Generally, an advisor is about 0.25% equity in options. That's generally true. Now, there's an agreement I like to use. It's called the FAST agreement. It's developed by Founders Institute, just right down the street in Palo Alto here. And it has a little grid attached to it where you can determine how much to give an advisor. It's basically how early is the stage of your company and how involved is the advisor. And you find their position on the grid. And it'll be somewhere between 1/8 and 1% usually. Percent of the fully diluted capitalization of the company. So all the stock of the company. Typical advisory board member, we start at 1/4 of 1%. Rob likes me to take questions at the end here. So just, if you hold your questions, I promise I'll get to them. All right, sorry. Okay, that's founders and that's advisors. The thing about advisors to keep in mind before you start running out and signing these people up, and the same thing with founders, once we figured out how much stock we should give to them, how do we keep them involved and engaged in the company? And that's where we want to put in place vesting restrictions. It's just so important. There's nothing that'll kill a company faster than not having vesting. So, does everyone know what I mean by vesting? So that's the concept that the stockholder earns into their shares through continued service. Typically, a founder will have 3 or 4 years of vesting. In other words, you have to stay with the company that long in order to fully vest in your shares. And that means when you leave, you keep your vested shares, but the company can buy back your unvested shares. So a typical 3-year vesting schedule with a 1-year cliff means that if you stay for a year, right, and then you leave, you keep 1/3 of your shares, but the other 2/3 get sold back to the company at cost, which is pretty close to zero. They're forfeited in effect. That's vesting. Founders typically 3 or 4 years. Rank and file people typically 4 to 5 years. That's consultants and employees. Advisors typically 2 years. Okay, because the advisor's there for a very specific purpose. It's usually a shorter vesting period, and the advisor's vesting will typically accelerate, meaning all the shares will vest when you sell the company. You'll see that more often in an advisory agreement. So don't freak out about that. Oh, here we go. So acceleration, just so you know, the idea behind acceleration is that, let's say I'm a founder and there's 3 of us and I'm subject to vesting. I might be thinking, well, gee, I've got 3 years of vesting. What if we sell this company within a year? I don't know, I think I should vest in all my shares. So in other words, if Microsoft comes along and we do a stock for stock deal, so I get stock in acquiring company in exchange for my stock in selling company, that stock and acquiring company will have that same vesting schedule. So I got to stick around after the deal. I might say I should be able to exit at that point. I should be able to be fully vested in all that stock so I can leave and sell it. You generally never get that, okay? That's one type of single trigger. It's called single trigger because it triggers full acceleration. Another type people used to talk about is, well, what if I get terminated without cause? There's 3 of us, 2 of them, they can gang up on me, they can fire me, and vesting, if you're not working for the company, you got to give back your unvested shares. So how about we put in a single trigger that says if I get terminated without cause, so it's not my fault, I'm not coming to work drunk or anything, then I should get full vesting. That's another single trigger. You never get that. Sometimes people ask for it, it's never awarded. What you do get sometimes is double trigger vesting, which means that if both of those things happen within a short period of time, then you get accelerated or full or partial acceleration of vesting. I mean, you get extra shares vested. In other words, if the company gets acquired and it turns out I'm redundant because, I don't know, I'm the CFO and I already have a CFO, and because of that they terminate me, well, okay, that's remote enough, we'll let you vest in your shares. So here's kind of the interesting thing about that. I did a talk yesterday on M&A exits. And in my research for that, because believe it or not, I do research these things, I found out that very few deals these days are stock for stock deals. Very few are fully stock for stock, 2 to 4%. Is it ever going to be that you're going to sell your company solely in exchange for stock of another company? So it's pretty rare that you're going to take the vesting that you have on your shares and apply it to the shares you're getting. A much higher percent is stock and cash, I'll admit. But by far, like 80% of deals are for cash, right? And it's cash. Now the vesting can still matter because you might have, because the cash might be deferred. It might be over a period of 3 years. In fact, usually it is. And your vesting might mean that you have to be employed by the company, the acquiring company, in order to get your cash. So it still matters, but probably not as much as you might think. So not an issue I'd probably fall on my sword over. I'll talk about management and control of the company a little bit. So corporations are managed by a board of directors. Directors select officers. Officers sign contracts. Your first board of directors should be no more than 3. Okay? Don't make the mistake of getting too big a board. And make sure people know that they're going to have to come off of that board when you get an institutional investor, a venture capitalist. So no more than 3, maybe even just 1. That's very common. Now when your investors come on, your first round, your first equity round, your first priced round, they're going to want a board seat. You will not give up control of your company. You should not give up control of your company when you do your first equity round, meaning you're not going to sell more than half the stock. It'll typically be 20 to 30%. You'll have another tranche reserved for option plans. And you shouldn't give up control of your board. You'll give up 1 board seat. At worst, investor will have a board seat. This is the venture capitalist in your A round. Investor will have a board seat. You, the founder, will have a board seat. And the third one would be somebody that you agree on, or it'll be somebody selected by the rest of the common stock. So you, the founder, you don't have complete reign over the company anymore after you take outside money. But on the other hand, you haven't turned your company over to the investors yet. That'll change in Series B. But Series A, just plan for giving up 20, 30%, maybe 40, having a reserve for an option pool, but you stay at above 50% stock and 1 or 2 of 3 members of the board. Now, so where this becomes a problem is a lot of people want to be in that boardroom. A lot of people want to be in there making decisions, but you don't want a big board. It's just too hard to get people together. You have to gather them together. They have to vote on stuff. They're traveling around the world. If it gets to be a big board, it's hard to get quorum. So how do we accommodate this fact that we want a nice, small, odd number board, by the way, so we can take action? We want a nice, small board, but we want a lot of people to have a say in this. And that's where we get this concept of observers. And those are people who can sit in the boardroom, they can participate in the discussions, but they just can't vote. So when it comes time to vote, they can't say anything, but they can certainly weigh in. We do that almost always once you get into the later rounds, because there are so many stakeholders. You put together an equity round and you've got a lead investor and a bunch of participants behind them. You want to have observers so they can have a say in what they're doing. All right, super voting stock. You've all heard the story of Zuckerberg and Facebook. This question comes up enough where I want to mention it. So the idea is that you get a founder that says, in fact, I hear this a lot, and most of the time I talk people out of doing this, but sometimes I don't. It's Class F stock. And it's the idea that there's a class of common stock that the founder owns and has super voting rights. Because the founder is looking at the cap table and saying, okay, I've got a majority of the shares today. Once I get an investor, that's going to dilute all of us, and us common stockholders as a whole are going to have a majority, but I'm going to have less than 50% once we take in outside money. So I'm not going to be able to control the company unless I have a bigger vote. So that's the idea of Class F stock. It's founder stock that has this super voting component to it. So the founder can maintain control of the company throughout past Series A and can maintain control and vote on behalf of all of the common stock for a long time, theoretically, throughout the company's life. So that's the idea. That's a founder who really needs to maintain control. He sold a lot of common stock to optionees, service providers, advisors, what have you, but he doesn't want them running his company or being able to block his decisions. Now, I just said I talk people out of that a lot. The reason I do that is because I don't see investors let you get away with it, right? You know, maybe in your A round, but eventually the investors typically will negotiate that away. They don't want any one person having that much power in the company. They don't want any one person being able to block anything. So not always, but you know, unless you're a real superstar, you know, you're probably not going to get those rights. So I tend not to bother with it. Well, talk a little bit so this is how to get your company ready for venture financing, right? Those are just some things that you probably ought to know about. I want to talk about some of the diligence issues that are going to come up. So this is California, it's 2020. As of January 1, we had a whole bunch of new laws come into effect. I will tell you that many of them are unique in this country and will surprise people from outside the state when they come in to do acquisitions or investment. And they're no more prominent than in the area of employment law. Does everybody know about AB 5? You've heard about AB 5, yeah, the anti-gig economy bill. So AB 5 is the law that has just now become effective. Sorry to have been struck down by a court as it applies to long-haul truckers, interstate truckers. So AB 5 is the bill that basically treats Uber drivers as employees. Let me put it that way. So if the test now for whether someone's an independent contractor or an employee, the test now under this statute is it's a bunch of things, but the important factor is that if the service they're providing is basically in the line of business of the putative employer, then they're an employee. So for example, the Uber driver, they do rides, right? They give rides to people. Uber's in the business of providing rides to people. Bingo, they're an employee. We don't even look at any of these other factors. They might do this for other rideshare companies, doesn't matter. They might have their own car, doesn't matter. They might have other jobs, none of that matters. You know, that's the test. That's AB 5. That's what's causing all the problems. It's a radical, radical change. Now it only applies for purposes of our labor and unemployment code. So that means that they have to get overtime, they have to get meal breaks, but it also means they can bring class actions if the employer gets it wrong. So that's why you're going to see a ballot on a referendum on the ballot this fall, I promise you, trying to get that law reversed because it's pretty significant. It's put a lot of companies out of business. I don't know if you're in that business, but I can tell you it is significant and it surprises people from outside. Why I'm mentioning it is that it's another diligence item that a venture capitalist is going to have to think about. Because before, this was an annoying issue, but the rules were such that a lot more people could be independent contractors. Now, almost nobody can be, unless you're in one of the statutory exceptions. So when AB 5, so let me tell you a little bit about AB 5. A couple years ago, there was a Supreme Court case called Dynamics. And that Supreme Court case actually created this new rule that treats basically gig economy employees as employees, gig economy workers as employees. It created that standard, that factor that I just told you about. As soon as that court case came down, pretty much every trade group in the world sent teams of lobbyists to Sacramento to lobby to get a statute passed to change the rule. So it was a good news, bad news thing. The good news is Sacramento paid attention, they talked to the lobbyists, they took legislative action. The bad news is they took the wrong kind of action. Instead of repealing the rule, they codified it. All right. So now, and the governor signed it. You know, another surprise. So now we've got this. We have to live with it. Why am I spending so much time on this? Because it is a big issue, and it's a big diligence issue. And if you're a startup company, and I know you're kind of cutting corners, and maybe you're paying people with stock, or maybe you're deferring their pay, or maybe you're not paying them at all, maybe you're calling them interns. Be careful. This is going to come up in diligence when you do a financing because it could take the company down. If you don't believe me, there's a company you should Google called HomeJoy. They raised $30 million of venture capital. They were an online platform. They had home housekeepers. So if you're a consumer and you're sitting at home and you say, gee, I could use a housekeeper, you go online, you find HomeJoy's platform, and you say, send me a housekeeper to clean up my house. They find one of their gig economy workers. They send him or her over. They clean it up. I pay HomeJoy. HomeJoy pays the housekeeper, and everybody used to be happy. Not anymore. Those people no longer have a job. They'll have to move back in with their parents because California has deemed that they're not being protected enough. But that's not the bad news. The bad news is HomeJoy got sued by one of those people. Class action lawsuit. Remember what I said? Class action. Employees can sue on behalf of everybody else similarly situated, and that ended the company. And the CEO told Recode that the reason they couldn't raise any more money was because of that lawsuit. So this is a big issue. You know, VCs won't invest in that sort of lawsuit. Deferred comp. I want you to be careful about this. I'm telling you about diligence issues that are going to stop you in your tracks before you can close your venture funding. A lot of companies, you can't pay people, right? So you defer the compensation. So I'll tell you what, it's sort of the wimpy approach. Remember Popeye? Is anyone here old enough to remember the Popeye cartoon? That's right. I will gladly, if you give me a hamburger today, I will gladly repay you on Tuesday. Okay, that's deferred comp. You know, work today and I'll gladly pay you next year after we get funded. That creates all sorts of tax problems. I'm not saying you can't do it if it's properly structured. I'm saying it has to be, you know, very carefully tailored, because otherwise you create a tax penalty that could be half the amount of the deferred comp. Invention assignments. I want to mention this because it's something that is easily overlooked. So when you if you're a tech company, you need to be able to tell your venture capitalists that you own your intellectual property. And the term ownership, that's a legal term, it's a term of art, and what it means is that you can keep other people from using it, right? So if I own that chair, my rights of ownership include the fact that I can keep anybody from sitting on it if I want. Same with intellectual property. I can keep other people from taking my idea and doing something with it. Well, suppose you hire somebody to come do some coding for you, or to do something technical, or to help you with it. They might have a non-exclusive right to that IP that they created, unless you've got a very clear document that says that whatever they created belongs to you, the company. So you need that, because without that document, you can't tell the VC that you can keep that person from using your IP. If you can't tell them that, you can't claim ownership. So invention assignments are very important. So, you know, make sure that everybody who touches your trade secrets, your IP, will assign their rights to that IP to the company. And then finally, I want to mention the currency that we use to compensate people. So first of all, before we get into this, you know, this is for both California and federal purposes. We have a minimum wage law. So if somebody is an employee, they have to be paid in cash. They have to be paid currently, right? You cannot pay them just in stock. You would violate our minimum wage laws. All right. You can't promise to pay them later. You'd violate our minimum wage laws. Now there are exceptions. There are exempt employees, for example. But the biggest exception is what we call the founder's exception. So this is a partner's exception. So for federal minimum wage, you know, founders typically, they're like partners, and partners don't have to receive minimum wage. We don't have that exception for California purposes. So again, once again, welcome to California, right? So you could be violating minimum wage laws without knowing it. Now this is one that the VCs will accept. You know, they'll understand that. And the reason why is because not many founders are going to sue their own company for a minimum wage, right? It just doesn't happen very often. I'm not saying it never happens. If the founders have a falling out, it will happen, possibly. But usually we'll just live with that risk. But everybody else, everybody other than founders, you know, they have to be paid currently. Now, you can pay them cash and stock, or cash and options. The trick here is that when somebody gets paid in property, that's a taxable transaction. Stock is property. So if you start handing out stock to people for doing services, you're creating a taxable event for them. It's usually a really bad result. That's why we have options. Does everyone know what an option is? Right? It's a right to buy stock at a certain price, right? The strike price. So the grant of an option is not taxable. When they exercise the option, it probably is, usually is, unless it's an ISO, but the grant of the option itself is not. So that's why we use options in this valley. About 15 years ago now, the tax law changed to make options really expensive to grant, because you have to get a professional valuation. And valuations used to be really expensive. So people stopped using options about that time, or they slowed down. There were less option plans in place. And companies would defer putting option plans in place until after they got funded. So they'd be hiring people and they'd say, look, we're going to pay you minimum wage and we're going to give you options in our company when we get an option plan. Can't give you an option today, don't have a plan, costs too much, got to get a very expensive valuation. But what we'll do is we'll give you an option a year from now after the VCs give us a bunch of money and we can pay for that valuation. That's the usual way of doing it now. Now, what I want to say about this is that the price of the valuations has just gotten dirt cheap over the last couple of years. And because of that, I'm seeing more and more people use startup companies, pre-funded companies, putting in place traditional stock option plans so they can grant options as currency. Because the problem with saying, you know, I'm going to give you an option later when we get an option plan, I mean, if I'm the employee, I'm thinking, well, wait a minute, the price is going to be high later. I want today's option price, which is almost nothing. I don't want your option price after you get venture capital funding, which is going to be, you know, much higher. You know, plus I want my option too. I don't know if you're ever going to put an option plan in place. So just a little trend there. Option plans are coming back in vogue. All right. I want to say a few words about patents, unless Steve, you want to make a cameo appearance here. Steve Covey is the patent lawyer in our office, and he knows more about patents. Oh, geez, clap, clap. You got to get in front of the camera.
Yeah, I see. I'm coming from the back of the camera. So I'm Stephen Colby, and I direct the IP Strategy Group. I am a long-term patent attorney. Mostly, I prosecute patents, which means I work with startup companies and figure out what they need. And apparently, I'm not loud enough. Okay, so I work with early-stage startups. I help them with their IP strategy. I help them get patents. I help them figure out why they want patents. I also work with a lot of the angel funding groups. I find that when I get funding from my clients, they pay me, which is really good. I also, oh my gosh. I also work on a lot of the things. Our team at Royce Law is very interactive, so I work with the corporate groups and the employment attorneys and so on. We have an entire team that has everything a startup company could want. My background is I was a CTO for many years. I've been a CEO, so I am very deep into the startup culture, and I love it very, very much. On the IP side, I do a lot of the early due diligence. When two people come to me with just an idea, I am ready to ask all the questions that Roger's talking about right now, and those questions about where you're getting your money and who's working with you and who your current employer is, all the things that could cause hiccups. I'm one of those people who asks those hard, tough questions when you're just getting started. And that's kind of the attitude of the whole law firm. So if you have any specific patent questions or IP questions, I'm going to be here after Roger finishes.
So Steve, could you
talk
on what a patent is and why people want it?
Why do people want it? That's a tricky. So a patent allows you to exclude other people from doing something. If you have an invention, you can come to a patent attorney and spend a bunch of money on it and get a patent, and then that gives you the right to go to court and tell somebody else to stop doing that. That's kind of basically what a patent is. But for startups, patents are a lot different. The reason is that enforcing a patent is maybe $2 to $4 million. The legal cost of doing that. So if a startup is going to enforce a patent, they're probably no longer a startup. They're in a patent enforcement company. The value for patents and other types of IPs for startups is increasing your valuation, making you more valuable every time you get funding, so that you convince that your investors that you know what you're doing and there's actually real value in them, in you. And then on exit, your goal is to probably either sell your company to some much larger company like Google or Facebook and walk out of there with a big fat pocketbook. Well, the patent portfolio you have when you sell is going to make a big difference in what you get for your company. I have seen literally cases where two almost identical companies are being sought after. The one with a better patent portfolio sells for almost $400 million, and 2 weeks later the other one closes down. And it was the IP that made the difference in that case. So getting a good patent portfolio is something you do to make your company more valuable and more appealable. That's it.
Which is better, trade secret or patent?
It depends on what it is. I have like a 2 or 3 page, well, it's more like 4 page now, memo on trade secrets versus patents. And it depends on what the secret is, what you do to keep it, whether it's protectable, whether it's patentable. The thing about trade secrets, though, is you actually have to do something about them. There's been plenty of legal fights in the past where some employee leaves and goes to another company and spills all the beans. And then says, well, I didn't know this was a trade secret. So companies, just like patents, if you're going to have some trade secrets and you're going to try to make those the things that make your company more valuable, you need to document them. You need to have a trade secret program where people who have access, they sign off on it. They need to have, when an employee leaves, you have to remind them, here's the 4 trade secrets you saw, and here's the documents that you signed, remember? So that 3 years later, when they're their next, 2 jobs down the road, they go, oh yeah, I can't say anything about that. Otherwise, trade secrets tend to, how do we say in Silicon Valley, they go into the cloud, and you never know where they're going to end up. So there are things that I can advise, and they're much cheaper than patents, but you actually have to do some work. You have to spend maybe 10 hours work, and you can get a great trade secret program in place. But you can't just say, oh, this is a trade secret without doing anything else. Right?
All right. Thanks very much, Steve. So we're gonna talk about that. So let me just add to that about the patents, because just 2 things I want you to take away from this. Number one, the mistakes companies make with this is they wait too long before they actually file the patent. We're on a first to file system here in the United States now, so it's important to file early. And I know it's very expensive to get a patent. Guys like Steve, are pretty pricey, but no, he says he's not. Okay, but
so I work with startups, which means companies that have very little money. So I can, a patent application, getting a full patent application file is about $15,000 to $17,000, which you probably in your first year of operation would rather spend somewhere else. We can work with you and get provisional applications on file and just get stakes in the ground so that you have initial protection before you go out and come to me before you talk to investors, right? Because we can get some initial protection for you, probably on the order of about $2,000, where you're doing a lot more of the work. But I'll handhold you and get some provisionals filed, and that's really the way to bootstrap. And then you have a year within which to raise the money and file a full patent application. And if you haven't raised the money in a year, my suggestion is usually try something different at that point.
right, thank you.
Yeah.
So design patents, so you mentioned that for a startup, it's more about valuation. What about the design patent?
The design patent is usually much more limited in its value. It might be on the design of a hubcap or a tire or a speakerphone. The Polycom speakerphone is actually an example of a really valuable, that was a very valuable design patent. But they're rare, they don't really give you much. They're a good way to differentiate in marketing, but if something has utility, if it's useful, then it's got to be utility patent, not design. Right?
Okay, so just anecdotally, I think your takeaway from this should be, because sometimes you hear people say, gee, we're going to rely on trade secret, not patent. Like Steve says, that can make the difference between being a funded company or being in the graveyard. So patents are important. They will increase your valuation. You should take care for that. Secondly, trademarks. Trademarks are important. That establishes your brand, that identifies your company, and it is so wrapped up in the goodwill of your company that you want to make sure that you have the right to use your name and mark. And so what you should do early on in your business's life, when you finally get a name or a mark that you like and you're going to use, first do a Google search. Be surprised how many people don't do this. And then secondly, you should do what they call a patent and trademark knockout search and see if anybody has taken your mark. Because what you don't want to do is put a lot of time and money and effort into building all this goodwill around this name, only to find out in due diligence you don't have the right to use it, or to have a cease and desist letter that says, you can't use that name. For some companies, as you can imagine, a name is so tied up with what they do. I mean, imagine your Snapchat or something where you're just relying on users knowing your name to come back to your site. If you can't use that name, you've lost your value. And if you don't figure that out, the VCs will. And then finally, trade secret, what Steve was just talking about. This is, I don't have a client that does not have trade secret information. This is typically the most valuable intellectual property asset you have, but it's also the easiest one to lose. And here's why. So it's got to be three things to be a trade. And by the way, a trade secret, it's something that's valuable, it's proprietary, it might be a process, it might be your software code, it's not patentable, it's valuable information, proprietary information. And it's got to be three things. It's got to be valuable, okay? Has to be secret. And as Steve was talking about, you have to take reasonable efforts to protect it, to maintain its confidentiality, to maintain its secrecy. What do you think is a reasonable effort? What would be a good example of that? That everybody should, have as part of your standard arsenal. And an NDA is right. An NDA. Everybody who sees your stuff, if it's secret, they got to sign an NDA. Otherwise, you're going to lose trade secret protection if you're not careful about protecting it. That's the first thing you should do. There are a lot of other things. You should, if you've got the time and you're interested in this topic, take a look. Google interestingly enough, the Google Waymo court cases, and you will see the lengths that Google went to protect and establish its trade secret information. Very extensive documentation and writings and evidence that, look, this was developed right here, at this date, at this time, so they could prove that it belonged to them, that it was trade secret. You as a startup should be doing that. You should be having a notebook, you should be documenting, everybody should be documenting what they're developing and where, and marking it confidential, so we don't have any question about this. Like I say, it's very easy to lose trade secret protection. I think we talked about this enough. I do want to move on from the legal part about this to the intellectual property part that has to deal with how you're going to approach the market. And a lot of times companies, when you're getting started, especially if you're a tech company, the temptation is almost irresistible to just develop the technology and then license it to somebody else. And there's nothing wrong with that. That is a perfectly legitimate, perfectly respectable business. But I will tell you that attracts a different kind of investor than a venture capitalist. That typically attracts somebody who looks for a little less return and a little less risk. And this is why. This diagram right here. Generally, if you're a licensing play, you would expect to put less money into your actual product because you're not investing in manufacturing facilities, you're not investing in a lot of the things that the actual manufacturer is. So you're going to have less upfront costs. But again, you're going to have less return on the back end. So that's exactly the opposite of what a VC is all about, right? The VC is about risking lots of capital up front for that really huge return on the back end. So venture capitalists typically don't like licensing plays because they're giving away too much of the upside. It's a lot like buying into a company that has a lot of debt that has to be paid before they can be paid, if you think of the license in that way. So just something to think about when you're thinking about approaching the market and how you're going to organize your company. I think we've talked about IP ownership. I do want to talk about, we got about 5 minutes, so I want to mention something about joint ventures and licenses. And this has to do with how you're going to enter the market as a startup. I mean, part of the big thing that we do, especially in this valley, with our clients, is to protect them from giving away the farm, so to speak. Because a lot of companies, they'll come up with a really good technology. And remember what we said, they don't want to be this guy. They don't want to be a licensing company. They want to go for the gold, right? They want to be a company that could be venture financeable. But they need to get some revenue. They need to get into the market. So they'll enter into joint ventures and licenses with really big companies. You have to be super careful about that. Don't ever sign anybody else's agreement without carefully reading it. Because the larger companies oftentimes will have an assignment of IP right in their agreements. So in other words, yes, we're going to take your product, we're going to integrate it into ours, and we're going to sell it so you get market validation. And by the way, we own everything. That's what the big company agreement will oftentimes say. I see that over and over again. And it can be very sophisticated and very complex, but the fundamental point I want you to keep in mind is you really need to keep control of that core technology. Now that doesn't mean you can't do joint ventures and licenses. That might be a really good way of proving that your product works. For example, if your particular technology has applications in a lot of different industries, a lot of different fields, you might give somebody an exclusive right in a particular geography to execute on your technology. So, for example, we're being recorded, so I have to be careful about who I talk about. But for example, if you have a technology that enables consumer goods, and you want to know that the consumers will actually want that product, you might give somebody in a joint venture arrangement an exclusive right to market that in a particular city. I've done that before. Why? Because even though they've got that city forever and ever, we are able to show the world that there's a market for this, that the tech works and that people will buy it. So this is a very strategic thing, and you should really get together with your lawyer when you think about how you're going to approach the market, not only whether you're going to license or manufacture, but basically the agreements you're going to enter into, how that's going to affect your whole business and your whole business strategy, because that goes right to the core of what the VCs are investing in. IP ownership we talked about. I want to mention a couple, we only got 2 minutes left, so I finally get up to capitalization. This is a typical cap table, and you know, when you sit down and start thinking about selling equity to investors, this is an exercise you will go through, and you will strategize, or you should, and you will do what ifs. And you say, what if we sell this much stock? What if that guy votes against me? You know, it's that kind of thing. And you should set this up on a cap table, and you can basically play this out under a lot of different scenarios and a lot of future financing rounds. Gives you a really good idea of where you are and where you're going to be after various financings. This one here goes all the way, only goes past Series A, but we could do this through Series B. Now you'll notice I have two numbers in the columns. We have the percent outstanding and the percent fully diluted. Those are two different numbers. Fully diluted, you're going to hear that a lot. Fully diluted means that we assume that all options that are granted are exercised. Sometimes it's, you know, vested options are exercised. And it means all convertibles convert and all warrants exercise, etc. All of those instruments that could be stock turn into stock. That's a fully diluted number. The real number is really the percent outstanding, where we don't count options because they haven't exercised yet, they're not stock, and they can't vote. So those are two numbers you'll want to pay attention to. All right, the last thing I'll mention, because we're down to the end here, has to do with funding. So these days, so when you go to do a venture round, you're going to do what they call a priced round. The VC is going to want to buy preferred stock in your company. That's a whole nother hour discussion, okay, as to what those terms are. Before you get to that priced round, you're going to need money, right? You're going to need friends and family money. You might need some angel money. The way we always do that these days, almost always, is through what they call a SAFE. It used to be convertible notes, but now it's a SAFE. A SAFE is a simple agreement for future equity. It goes by other acronyms, but that's the general idea. The investor gives the company money. The company promises to give the investor stock when it sells stock to the VCs. It will give them that same preferred stock at a discount and subject to a valuation cap. Now, you should know three things about this. Number one, please do not download a SAFE agreement from the internet and try to do this yourself. You're going to be surprised if you do, because the ones on the internet, sometimes they're drafted founder favorable, sometimes they're drafted investor favorable. Most of them are investor favorable now, and you might be giving away more stock than you think you are with these simple agreements for future equity. To say nothing of the securities laws requirements that you need to be concerned about. But a pre-money safe, for example, if my safe converts, if I buy a $1 million safe for a company and it converts into stock on a $4 million pre-money valuation, that means I have 20% of the company, you know, when the safe converts to stock, right? If it converts on a $4 million post-money valuation, it means I have 25%, right? So there's little things in these documents that can make a big difference to how much of your company you're giving away. Valuation cap. These days, investors will always want a valuation cap. They want to know their safe money is not going to create a company with such a big valuation that they end up with a very small percentage of the company when they got in first, when it was really super risky. So we'll say, look, your safe is going to convert at the preferred stock price, but at no higher valuation than X. X is usually about $8 to $12 million these days for an early stage company. And that means they know they're going to get at least a certain minimum percentage of that company when they do the safe conversion. And finally, the discount. That means the safe is going to convert into preferred stock at a little better price than what the later preferred stock investors get. That's your reward for getting in early. So if the investor is paying $1 a share, you're paying 80 cents a share, you the investor, something like that. Okay, well with that, Rob, I think we're going to turn this over to you. Sorry I didn't get through all of my other stuff, but maybe we'll do another presentation.
Hey, let's hear it for Roger.
By the way, if anybody wants the slides, I got through about half of them. Just leave me a card. I'm happy to share those with you.
Or email Roger directly. So we've got a full half hour of questions. We want to take as many questions as possible. Once again, it's not legal advice, but it's free. So go for it. 8:30 p.m. we'll end the
Get what you pay
program.
for.
We have a raffle. We have some great items, including a book by Roger Royce, down on the arrival. So we've got each other to win, and then we break out the chocolate mousse cake and Haagen-Dazs ice cream. So who's got a question for Roger? Ned, wait a minute.
Ned has a question.
So this microphone does not amplify, it records. So keep that.
I'll repeat it.
Tell me if it doesn't work. It works.
Thanks, Roger, as usual, for a very enlightening presentation. One of the challenges I have as a founder is that my company offers equity and utility tokens.
Oh, God. Okay.
So one of the challenges we have is that it's difficult to factor into the valuation of the company the fact that there are tokens which could actually exceed the value of the intended equity raise. And investors have not, conventional equity investors have not yet gotten around, and there is a communication barrier. What are your thoughts about how this could be best communicated? I actually created a formula where the equity can be dynamically evaluated based on how the token raise goes. So the higher the token raise, the lower the equity is. But that doesn't seem to be very popular. So what are your thoughts on that?
Your question is, how do you communicate that to investors?
Well, essentially, what are your thoughts on how you do the equity valuation with the presence of a token raise?
Of a token raise.
How do
Yeah, so
do that?
let's level set here. So what Ned is talking about are tokens based on blockchain technology, I assume. Digital assets. Everyone knows what a token is. It's a form of cryptocurrency, we'll say, although it's not a currency. In this case, it's a security. So it's a digital asset that is tied to some real-world service, value, or asset. That's the utility that you usually see in these tokens. So in other words, when somebody buys your stock, maybe you give them a token, which is this digital asset, a right to some service, that's the utility, or maybe it's a right to some asset, that the company owns. That'd be a security token. And when we go and launch these into the market, that's often done through what they call an ICO, an initial coin offering, because it looks like an IPO. You're just distributing them out into the open market, and people are buying it. Why do people do this? Why do we use these digital assets? First question, it's because of liquidity, right? So here a company, it's called non-dilutive financing, right? Here a company can it's almost like pre-selling its product or its service. So the company sells these tokens instead of its stock, so it doesn't dilute any of the stockholders. They get the money, the investor, they've got this digital asset that hopefully will increase in value, but they can usually often, their goal is to put it on an exchange so they can sell it very easily. Private company stock is very difficult to sell, right? I mean, not just for legal reasons, because it's hard to find a market, but the idea behind tokens is you put them on an exchange and you can find a ready market for it. So that's why tokens are attractive. So the legal issue, of course, is that they are securities, and they're subject to all the securities laws, and the Securities and Exchange Commission has really cracked down on this, and they are continuing to do so. I looked at their website this morning about this because I'm writing a chapter for a book on blockchain, and they say on their website that they've gotten more friendly, and et cetera. more cooperative. They got more rules around this. They've given us more guidance, but it's really not true. The United States securities regulators are hostile to tokens. That's why you're one of the few that's doing it here. Most of my clients have gone to a different country to do their token offering. So the venture community, to get back to your question, so they hated these things when they first came out. And one of the reasons why is because suppose a guy like Ned, he has a bunch of tokens along with his stock. Well, Ned's a founder, the VCs, they want Ned to stay in this company as long as possible. They want those golden handcuffs. The last thing they want is for Ned to have early liquidity, right? Which you get with the tokens. So I've heard VCs say that. We don't want to invest in a company that's going to do tokens. In fact, we're going to put that right into the documents, and I've had to negotiate that language. It says this company will not issue any tokens. We will not do an ICO. The more friendlier VCs would say, you can do a token offering, but you got to give us an allocation if you do issue tokens. So I think the answer to your question is you got to find smarter investors because the token economics is so complex. Even not even doing what you're doing, just understanding how the value is going to increase, how those network effects can increase the value of the stock and of the company. I would find investors who understand that. And they're out there. Blockchain Capital, they love public blockchain companies. They understand it very well. There are investors that'll do this. So, not just for you, but everybody, pick your investors carefully. That's a long-winded answer to a short question, but oh well. Welcome. Anybody else? Oh, geez, I get to go home early. Oh, okay. Maybe not so much Airbnb, but if you're a platform company, if you're the kind of company that you use subcontractors, it affects you, right? If you use contractors, it probably affects you. I've had so many companies call me now and say a couple of things. Number one, three things. First one, the day the governor signed it, I had a company call me and say, we're out of business, because we're a platform. We're just like HomeJoy. Remember HomeJoy? And this makes all these people employees. I got to get workers' comp. We can't afford it. We're out of business. I don't think it affects you if you hire people if you hire workers is when it affects you. So I don't think it affects Airbnb. Airbnb isn't hiring anybody, right? They have a platform for people to rent, not to exchange services. It affects you if your platform is dealing in services. Yeah. But on that point, I've also had companies say, I've had people come to me and say, I used to do this contracting work for this out-of-state company, but now that they know that I'm an employee, they're not going to hire me. They fired me. They're going to go hire a guy in Nevada or Arizona or any of the other. There's 48 other states that don't have this silly rule. There's only one other that does. Yes, sir.
Yes, thank you very much for this information, Mr. Royce. Just a couple of quick questions. So first, you told us how much the advisor gets. You didn't mention how much the board of directors. What do they expect to get? You repeat the question.
Oh, okay, sorry. So the question is how much stock, what should you give a board member for being on your board? Well, I think that's a little less, it's a lot less market standard than it is for advisors because it depends. Depends on the stage of the company, depends on the size of the board, depends on how active your board is. I sit on several boards and my experience is that, as odd as this sounds, is that the board member gets a little less than what's standard for an advisor. And the reason I say that, when they start bringing in outside board members, and I think the reason why is by the time a company does that, because usually, here's why, because it's going to be, founders are going to be on the board, and then the VCs are going to be on the board, and then they'll get some industry luminary who will get a big grant because he's a big deal. But by the time they start bringing in like outside directors down the road, the company's built up a lot of value, so the stock is worth a lot more. So I'm seeing definitely less than 1% later on, probably more than that early on. But again, very, very, I think that's a much more fact-intensive issue. Board members, keep in mind, a board of advisors is way different than a board of directors. A board of advisors has no fiduciary duties, and they don't make any decisions, right? They're just there to advise. Directors, way less particular expertise, but they're fiduciaries. You know, they can actually make decisions that bind the company. So a lot of people get those kind of confused, or they equate them, board of advisors, board of directors, but they're much different. In fact, the board of advisors will probably never even meet each other, you know, whereas the board of directors will sit down and make decisions jointly.
Thank you for that. Just another one, if I
Okay.
can. You said that it's better to give stock options and not just the stocks
Yeah.
themselves.
Yeah.
So my question is, let's say that I'm giving this amount of stocks. How do I know how much equity did I really give so far? Like, is there like a calculation somehow that I know how many percentage all of those options really worth?
So the question is, if you grant options because people aren't exercising, how do you know how much equity is actually being given out? Yeah, they call that option overhang. And so there is an answer to that. And typically a stock option plan will be about 20% of your fully diluted capitalization of the company. Sometimes a little less, sometimes a little more, but typically around 20%. Of that 20%, they're going to be granted to a bunch of people, a big group of people. Enough that we can statistically sort of estimate, you know, how many people are going to exercise at any given time and how many people are going to leave without having ever exercised. It's close enough that that we'll just assume that all of the options issued and or vested will have been exercised for purposes of calculating our fully diluted capitalization, and we won't increase the value of the company by their exercise price because it's very low. So we just make that assumption. That's fully diluted. But you're right. The bigger that option pool, the more that overhang is, the more that uncertainty is. So I've seen companies where they say, "Oh, we're going to, you know, we don't want anyone to pay any tax on stock. We're going to give away 50%." In fact, I had a client. He's a founder of a public company, and he had like 30% of the stock of the company in options. It's crazy. You have no idea how much stock is outstanding when you've got one guy owns that many options, because you don't know if that one guy is going to exercise or not. You know, you can assume a broad group of people, you know, enough of them are going to exercise or stay with the company until it exits, but one guy you don't. And the other problem you have is when you start using options improperly like that, is at some point you got to say, wait a minute, the exercise price is kind of a big chunk of money. So if people exercise, the value of the company is going to go up. So they call that the treasury stock method of measuring, you know, what the options are worth, because you assume that people. So you assume the fully diluted capitalization, but you assume that they paid the exercise price, which increases your price per share. So it gets very complicated if you be careful with options. You know, if you get beyond like kind of our cookie cutter, you know, rules, then you can start messing up your capitalization table. Does that make sense?
Yes, I'm still a little bit confused about that. But
Well, I
I
didn't mean to
understand the main message that you're
yeah.
delivering.
Let me simplify. I didn't mean to confuse you with that, because those are the outliers. Those are the cases that don't happen. In a typical case, you know, you'll have two columns in your cap table. One is where is it? One is issued stock, and the other is fully diluted. Oh well, I had it there a minute ago. You remember. And the issued stock is people who have actually purchased the stock. They've exercised the option. That's the voting stock. The number that people look at is fully diluted, right? Because the VCs say, well, we're going to assume that every option that's been granted and is vested is going to be exercised. We just make that assumption for purposes of valuing this company and determining how much of the stock we get. That's how they look at it. So the answer to your question is, yeah, that you don't really know. You know, that's just the rough guess that we all live with.
Okay, thank you. Just one last question. I wanted to know.
Okay,
the
last
equity-
question.
Yeah, the equity that the advisors get, is it diluted or non-diluted?
The advisors, when you say, so the question is, do the advisors get diluted or non-dilutable equity? Don't ever use non-dilutable equity. You'll be sorry. I mean, I tell people to do that, and then they do it anyway, and then they're sorry. Because if something is, you know what he means by non-diluted? He means that you're going to promise somebody a certain percentage. So when a company's worth $1 million and they got 1% non-diluted, it means when a company takes in $9 million of investment, it's now worth $10 million, they still have 1%. So they made 10 times as much without doing anything. Don't do that. And what, as a practical matter, what that non-diluted means, and you see that sometimes, we use warrants in order to maintain somebody's percentage interest. The later investors are not getting diluted by anything you've done before they come in. When the VCs come in, they're going to make a pancake out of everything you've done. They're going to say, look, we want this percent, and if you got some deal with your co-founders that you're not going to be diluted, that's between you guys, That means you, the founders, are going to get diluted every time, you do that. The VC is not going to pay for your mistakes. They're not going to take your dilution. So I really don't think you should do that. Accelerators will ask for that a lot of times. Yeah, they'll want, but the way they say it is, we want 6% or 8% non-diluted through your first round. So you'll do that. Okay, it sucks, but okay, they're a big shot accelerator. We'll let them do that, and there's a cap on it. It ends after the first round. But once in a while you see people say, oh, forever and ever, you have 1% of this company. Well, that's coming out of you, the founder's pocket, if you do that. I wonder if I can get this to expand again. Oh. Okay.
So my question is, what's a typical structure that you set up for a Delaware Corp, let's say? So to make an example of my question, let's say I come to you and say, okay, I want to set up a Delaware Corp. We're all brand new. We've got 2 co-founders. Want to make sure we have the option pool for employees in the future and so forth.
Yeah.
So what I see is that you do 10 million authorized shares.
Yeah.
And out of the 10 million, what's next? Just the overall structure, just give me an idea.
Let's go back to my cap. That's the second cap table question. So I want to go back to it because I kind of went through that fast. The question is the structure. So I like to start with 10 million authorized. 20 million is just fine. In this case here, we've got, doesn't say how many is authorized, but this looks like there's probably 5 million authorized. But somewhere in that range. I like 10, nice round number. Of that, I like to issue 8 million to the founders and leave 2 million reserved for an option pool. Now, the tricky thing about Delaware corporations is that the bigger that gap between issued and reserved, you have to pay a Delaware tax. It's normally small, but the bigger that gap, the bigger the tax gets. And if the company you have to work your way through the calculation, but at the end of the day, once the company gets some assets, if you've got a big gap between issued and authorized, you've got a big tax to pay.
So 80% of the authorized for the founders,
yeah,
and then the other 20% would be for employees, advisors.
Right. 80 for the founders, 20 for your service providers is what I like to start with.
And then you would sort of go through that process until you get to Series A.
Then you go to Series A and you'll amend your documents. You'll increase your authorized shares for the. No, probably not at that point. At that point, you're just increasing the shares to include the preferred stock. But you know what? Eventually, the number of shares is going to go up, and it's going to depend on your valuation. Because what you're trying to do, this is more psychology than anything else, but you want to keep your stock option price relatively low, right? Because your employees, they got options. Everybody in Silicon Valley has options. And if they think that their stock option price is too high, if it's higher than the guy at the company next door, even though economically, we know that it depends on how many shares, what percentage, how many shares are authorized, we want to keep the price low. It's just psychologically, we keep the number of shares high, so we keep the option price low. And that also, it's just the way we do it. We keep the option price low. I know that sounds silly, but it's important.
And then what's a typical vesting plan you put in for that 80% of initial that you would set up?
Well, for founders, I'll vest usually 3, sometimes 4. 3 is founder favorable. 4 is more typical. Sometimes you see 5. And for the optionees, it'll be 4 or 5 years.
Okay, to follow up, my last question is, typically based on the deals you see with the VCs and raising funds in Silicon Valley today, which a lot of people are saying is a bubble and so forth, and so not chasing too much money chasing the deals. What kind of deals are you seeing in terms of percentage? So, for example, Series A, are you seeing 15%, 10%, 20%? Not on the conservative side, but on the best case scenario.
The best case for the company,
Yes.
meaning that they give away the least amount of equity,
Yes, that you see
10%. I see 10% Series A deals. That's the best case.
Okay.
Yeah,
to 20%.
yeah. 20 to 40. Here's the thing. So the VC, you know, it's the way fund economics, you know, are. They can't make that many bets because they really do have to manage that investment. They have to sit on that board. So they need relatively big pieces of the company, you know. So your typical VC is, you know, and then they're leading. They're probably bringing other VCs in. So 20 to 30 is probably more accurate.
So 20% for the leading or the group of,
The group.
the whole group?
The group,
What
yeah.
about the funding before that, so in a convertible note? it's the same?
Yeah, they all roll into that funding. They all roll into that financing.
Just typical for B. What about that? Is that only 20% usually?
You know, rules of thumb are kind of risky because every company is different. But my rule of thumb is that you're going to give about the same amount away to the B, which is going to put you over 50% to the investors after the B round. That's generally true, except in biotech, but that's generally true, I think. Okay.
So let's say there are three founders. One of the guys puts in some amount of money, others don't, about starting out the company. How do you suggest we split the equity in that case?
One person put in money, the other two didn't? Are you three equally, okay, three founders, one founder puts in cash, the other two don't, but all three of you are equally involved in the operations of the business? So one way to manage that is have the founder who put in the money take back a promissory note. So he loans the money to the company. He may have to contribute it later, but maybe he'll get it paid back. That's one way of equalizing it.
We still try to get a similar kind of equity to
And then, yeah, and then divide up the equity. So that's one way. That's assuming that all three of you are, you know, kind of equal partners in this. Another way is to do something like a dynamic split or a formula where we say, look, I put in money, so I should get this much. You should take a look at the online calculator. Money is usually worth like 4 times what services are in terms of what you should get. Says, look, I put in money, so I should get more than you two guys, you know, by a factor of 2 to 4. That's a formula that's used.
I have a question regarding the Class F stocks.
Yeah.
So can that be allotted to, suppose, a CTO or an advisor, or is it only for the founder?
It could be, but it doesn't. I mean, I don't know why you would do that. So the question is, a super voting stock. I mean, founders keep that. The reason you have that is because the founder doesn't want to give up control. So if he's going to take that stock and give it to an advisor, it kind of defeats the purpose. He's just giving control to somebody. I've never seen anyone do that.
Like I have a CTO who I don't pay, right? So I want to give him some profit stocks.
So you want to give him stock instead?
Yeah, I want to give him some profit.
Have you been paying attention? Did you hear anything I said tonight? Yeah. Okay, but I know that goes on. Yeah. There's no value. You don't get additional value. You're thinking of a different kind of stock, I think, like a preferred stock maybe, that's more valuable than the other common. This just has more voting rights.
Okay.
So, and again, it's all going to go away when the VCs get involved anyway. So it's sort of it's a fake victory.
Okay.
You have a CTO who's got stock, so you do have a technical co-founder.
I mean, he doesn't consider himself a co-founder because he died 2 years later.
Oh, I might. How much stock does he have?
He just leaves it up to me how much I want to do.
Wow, good CTO.
I make
See,
good connections.
that's why you're the business person and he's the technical person. Okay.
I'm a late comer to a startup. It has already got a team of 2 who have been working for almost a year, and I'm just joining, negotiating the equity. So for a late comer, before any investment, usually does he get an option or also hold the stock? Is it common to hold the stock before equity?
Yeah,
So
the question is, this happens a lot. We've got a company that's got 2 founders. They've decided they need a 3rd founder. 2 years later, they find you and they say, come on in, we're going to give you stock. you can be a founder along with us. Problem you got a tax problem now. Because when those founders formed the company, the tax rules allowed them to get their stock tax-free. 2 years later, now you come along, and the tax rules don't give you that same benefit. The reason why is it's tax-free if the transferors immediately after the transfer have more than 80% of the stock of the company. You're now the transferor 2 years later. After the transfer, you're going to have less than 80%. So you don't fall within this exception. You're going to be taxed on the value of your stock that's given to you in exchange for any property. You're going to be taxed on a value given for services. So you got one of two choices. You can take an option, but then we got the problem of the option overhang. You got this big, humongous option now that's unexercised, which messes up your cap table. So I wouldn't do that, but you don't get taxed on the option grant. Or you can buy the stock. And you're going to say, well, geez, I got to put cash into this company. Those other two guys didn't put cash in. Why do I have to? So we can ameliorate that. We can have you buy the stock with a promissory note. So in other words, you give me the stock, I'll write you this note. And then, of course, the problem is that note has to be paid someday or forgiven. And when it's forgiven, you get taxable income. Yeah, this happens all the time. We could go way down the rabbit hole on what your options are. But there's a way to skin this cat. It's not going to be completely painless, though.
I think since the team hasn't got any investment, I think if I buy stock, the price will presumably be still very low.
That's right. You can probably buy it really low right now, but keep in mind the difference between the value and the price you pay is taxable income to you.
Yes. That's how we find out.
Yeah. Okay, I think we got time for one more.
So with this late founder, they probably have a vesting schedule too.
Yeah.
And does the tax event occur on vesting or when they're granted?
So again, it's complicated. The general rule is the tax event occurs on vesting. And the amount of stock that vests is taxable income as of the time of vesting at the value at the time of vesting. So if the stock goes way up in value and it vests way out here, that's a really bad result. It's a lot of taxable income. You can make what's called an 83B election and close the compensation element and treat it all as owned and vest it for tax purposes on the day that you get it. So then when it vests going forward, you don't have any additional income. And by the way, for a startup company, we do that every single time. You would never do anything other than that. For a public company, you would never do that. There's too much value. So that's, okay, all right, take one more.
You obviously have worked at the end,
Yeah.
right from seed through C or going public.
Yeah,
So I work for a company, we provide infrastructure technology for companies.
yeah.
And like what AWS does. From seed to seed, do you see that there's a logical jump when a company says, hey, we're taking that next step and infrastructure grows? Like, so I'm trying to figure out focus on whether it's seed, which is great, or it's a server, or like when they get to the B series, they have cash infusion, now they want to take everything that they have and put it up to the cloud or get better, bigger, faster, stronger. Do you see that technology jumping at any one particular life cycle?
Well, if I understand your question, I think you're asking me at what stage do you do another financing? Is that it?
Well, just where you see that the growth really occurs from a startup, where then, that's, I focus on B series right now.
Yeah.
But from here today, I see a lot of people that can end up being unicorns. So I'm just wondering, in your opinion, where a growth really occurs in companies that are viable and they really invest in.
Yeah, I don't know. I think that's very fact specific, but I've got data someplace on how many. Well, here's one that I do remember. So typical exit in this valley, a company will have raised $51 million by the time it exits. So that means a lot of that growth, it seems to me, is coming later on in those later stages. But I think the big growth, percentage-wise, has got to be in the early stage because it's so risky that if they do make it to the later stage, they must have had a huge, it's in the early stage, clearly. By the way, typical company here will do 4 rounds of financing and take 7 years to exit. But yeah, I think the big, humongous growth is going to be in that early stage because there's so many more failures, at the early stage. So many, because there's a lot less money for the B and C rounds, right? So they're not going to make it. Only a certain percentage are. So it just seems the reason that that you'd have, you
So
know.
for say goes UCRC, A, B, and C.
Yeah, yeah.
So first prize, Roger. So by Roger Royce, Dead on Arrival, How to Avoid the Legal Mistakes That Could Kill Your Startup. You get signed by the author himself.
Keshav Narain, MD. Hey, what do you know?
Come on down.
Okay.
Claim your prize. You want to follow with Roger?
Thank you.
You want to follow with Roger?
Sure, yeah.
Oh, no, you hesitated there for a second.
Gotta find someone with a camera here.
It's a nice camera.
Yeah, hold the book up. There you go.
All right,
Okay?
next one.
Thank you.
Oh, Colby, drum roll. Next prize winner is,
Oren, with the smiley face.
all right, he's got a reason to smile now. Come on down.
Thank you, sir.
All right, congratulations.
All right. Thank you. Oh, it's
All
like,
right, thanks for.
actually my personal library, Leadership and the 1 Minute Manager.
I didn't write that.
Yeah, I know, it's-
Someone else has got it.
Okay, who wants to pick a card?
It's regifting, but it's still good. So you can draw a card anyway. And winner is,
Oh, we've got a couple winners here. Scott Williams.
Scott.
Oh,
Must be present to win. Going once, going twice. Scott went home. What?
All right, take another one
Snooze, you
here.
lose.
Jen. Hey.
Jen, come on down.
All right. You gotta
Congratulations.
get a picture with Rob.
Okay.
Since I didn't write that.
It's a long photo. All right, Kamal. This is the grand prize by
Yeah,
City
that's
National
right.
Bank. It's an awesome picture frame. Right? Picture diploma in it or something. All right, the winner is small.
Neil Ding. Neil.
Neil Ding. Come on down. All right. So, oh, that's
Okay.
right there.
Okay, do you have my card?
So now we will sing happy birthday to idea to IPO. Today is the 10th anniversary.
Oh, okay, thanks for being here.
Blow up the balloon.
Appreciate your support. All right, good meeting you. Good luck.
There you go.
Happy birthday to you. Come on, stand up. Happy birthday to you. Happy birthday, idea to IPO. Happy birthday